The State versus Nosiviwe Mapisa-Nqakula, case number 33/2024. This case illustrates the first layer of the framework. Corruption is equal to taking from the till or stealing from the cash register. The state alleges that while serving as a Minister of Defense, Mapisa-Nqakula solicited approximately 4.55 million rands and received 2.15 million rands in cash from a defense contractor. The allegations she denies. She faces 12 counts of corruption and 1 count of money laundering and has pleaded not guilty. Viewed through the till metaphor, the alleged wrongdoing is essentially about using the power and influence of public office to extract a private financial benefit. Unlike state capture or criminal infiltration, the alleged objective is not to control the institution or disable the machinery of justice, but corruption is to profit personally from access to the state, stealing from the till. State witness number 2, NOMBASA-NTSONDWA-NDHLOVU. This is the central witness in the entire prosecution. She has the sole directorship of Mkhombe Marine, which supplied logistics services to the SANDF. The 2025 High Court judgment confirms that the state had already identified her as a Section 204 witness. That means she admits conduct that could incriminate herself and may qualify for indemnity in the court, ultimately finds that she testified frankly and honestly. The SANDF contract. NOMBASA testified that Mkhombe Marine obtained a logistic contract from SANDF. That's confirmed, it's not disputed. One of the contracts discussed in evidence was worth around 79 million rands. Other reporting also referred to a larger, earlier logistic contracts that has been suspended and a replacement contractor has been found. Her basic proposition: after the business relationship with SANDF was established and she had the tenders, requests for money started immediately after that. Mapisa-Nqakula's lawyers have also stressed that their client, Mapisa-Nqakula, was not personally responsible for awarding the relevant tenders. The defense position is that the contractor dealt with procurement structures. The minister, Mapisa-Nqakula, did not simply award Mkhombe Marine those contracts or those tenders. That is directed at the state's alleged quid pro quo. What the defense is trying to do here is to completely destroy the quid pro quo, the gratification part of this whole entire prosecution. The prosecution does not necessarily need to prove that Mapisa-Nqakula personally signed an award in exchange for each payment, but it still has to establish the corrupt connection between gratification and the exercise or potential exercise of official influence. Dr. Sam GULUBE enters this prosecution. May his soul rest in peace. According to NOMBASA, the first request did not come directly from the minister, Mapisa-Nqakula. They came through Dr. Sam GULUBE, who was then the Secretary of Defense. She testified that GULUBE asked her for 300,000 rands, allegedly on behalf of Mapisa-Nqakula. NTSONDWA-NDHLOVU said she paid the 300,000. Then approximately a week later, another request allegedly followed, 400,000 rands. She says this second request angered and concerned her. Did the minister really send you? This led to one of the most important meetings in the state's case. NTSONDWA-NDHLOVU says she arranged to meet Mapisa-Nqakula at the Intercontinental Hotel at Oliver Tambo Airport. Her evidence is that during this meeting, Mapisa-Nqakula confirmed that she had indeed sent GULUBE to request the money. This is critical, very important. Without that evidence, the defense could argue GULUBE was asking for money on his own. NTSONDWA-NDHLOVU's version allows the states to say, nope. The minister allegedly confirmed that GULUBE was acting on her behalf. Now let's go to the code words. NTSONDWA-NDHLOVU testified that Mapisa-Nqakula proposed using coded language when discussing money. Among the alleged expressions were the wig, padcos, impepo, snuff, ancestral dreams related references in there. The state says it will use WhatsApp evidence and surrounding circumstances to demonstrate that these words represented request for money. This has become one of the major battlegrounds for the trial, because the defense question is, did these words really mean money? That has become one of the major battleground, a major background of this trial. The 200,000 rand and the robbery. NTSONDWA-NDHLOVU gave unusually specific evidence about one alleged payment. She said that in 2017, she was traveling with approximately 200,000 rands, which she intended to deliver to Mapisa-Nqakula, the minister. While in Spreetview, she was robbed. The robbers allegedly took approximately 12,000 rands from her bag, but she says they did not take the other money that she had kept separately in the bag, the 200,000 that was intended for Mapisa-Nqakula. She later told Mapisa-Nqakula that she had been robbed and what had happened. According to NTSONDWA-NDHLOVU, Mapisa-Nqakula did not show much concern about the robbery and still expected her to pay the money. The state obviously relies on this as a memorable event corroborating the alleged demand. The defense attack, Mapoma is the lawyer of Mapisa-Nqakula, pointed out that HOLOMISA's letter referred to 200,000 bribe that NTSONDWA-NDHLOVU had apparently not mentioned in the same way during the part of her testimony. The defense proposition essentially is that if the other accounts differ, one account must be wrong. So they're asking which account is wrong. For some reason, the defense is seeing some discrepancies in this $200,000 payment. Nosiviwe Mapisa-Nqakula is a major trial, guys. One that goes to the heart of alleged abuse of public office and public funds, stealing from the till or taking from the cash register. I'll be following this case closely and catching up on key developments. For updates and commentary, follow my channel and share my content across your networks. The gift-wrapped cash. NTSONDWA-NDHLOVU testified that some cash was presented in a matter representing gifts. She describes cash being wrapped or concealed together with personal items. This connects directly to perhaps the most memorable allegation, the wig, the $300,000 wig. Actually, when I saw this, I thought it was an actual wig, but it is not. By late July, evidence and cross-examination focused intensely on the alleged 300,000 rand payment associated with the word wig. NTSONDWA-NDHLOVU alleged that Mapisa-Nqakula demanded a $300,000 kickback using wig as the code word. That money was concealed beneath or together with a luxury wig at Oliver Tambo Airport. This is one of those allegations where the physical detail matters enormously. The defense is challenging whether the wig was genuinely a code. When that wig code was established, whether both women understood it that way, whether the surrounding WhatsApps actually prove that the state says it proves. So this is going to be complicated. Now we move on to the 2 million rand promotion demand. This is the largest individual solicitation alleged in evidence so far. NTSONDWA-NDHLOVU says Mapisa-Nqakula sought 2 million rands from her in connection with the possible promotion of NTSONDWA-NDHLOVU's husband, Dr. Noah-Ndlovu, a senior SANDF doctor. The state alleges that Mapisa-Nqakula visited NTSONDWA-NDHLOVU under the guise of having an ancestral message or dream concerning her and raised the question of her husband's promotion. NTSONDWA-NDHLOVU says she refused to pay the 2 million rand. Her position was essentially, my husband deserves the promotion on merit in any way. Her husband was going to be promoted because I guess he was the only one that was the next person in line. So she says she did, however, hand over a smaller amount, reportedly 150,000 rands, around that episode. This is important because it explains part of the difference between the 4.5 million allegedly solicited and the 2 million that was actually paid in cash. Solicitation itself can form the basis of a corrupt charge, even if the requested money was never paid. So the defense says, why didn't you tell HOLOMISA about the 2 million rand? The defense then focused on that 2 million promotion bribe. Mapoma, the lawyer, asked if this was such a enormous and serious demand, why didn't you tell HOLOMISA about it when you complained to him? NTSONDWA-NDHLOVU responded that she did not believe HOLOMISA needed to know everything that she was doing. This is a potentially significant credibility point because the 2 million rand allegation is now one of the largest components of this whole entire indictment, the ancestral dreams. According to the state's opening and NTSONDWA-NDHLOVU's evidence, Mapisa-Nqakula allegedly sometimes summoned and contacted her by saying that there was an ancestral message or spiritual matter she needed to discuss. The state alleges that these conversations then transitioned into requests for money. The prosecution says expressions such as impepo and references to Indumba were part of these coded communications. One alleged final $100,000 payment was said to have followed a message indicating that the ministers in Indumba had run out of medicine. Again, the state must prove that spiritual language actually meant money in those communications, not merely an assertion of that interpretation. The total amounts, the prosecution's formal allegation is approximately, as we have mentioned, she solicited 4.5 million rands and actually received 2.1 million in cash. The correction counts correspond to individual alleged solicitations rather than simply one global 4.5 transaction. That is why there are 12 separate corruption counts. Now let's talk about the money laundering count. The corruption evidence explains where the alleged money came from, but the 13th count requires another step. The state alleges that some proceeds were used in connection with the renovations of Mapisa-Nqakula's Johannesburg home. The prosecution has indicated that approximately 1.67 million was paid in cash to service providers connected to those renovations and alleges that some of those funds were proceeds of corrupt payments. Mapisa-Nqakula admits that the renovations occurred. She does not admit that NTSONDWA-NDHLOVU's money funded it. That means future financial witnesses are likely to be in very important money movements here. She has to explain how she funded those 1.67 million rands in home upgrades. She has to explain where she got that money from because she was paying in cash. Now, NOMBASA's Section 204 is a problem. This may become one of the biggest credibility battles in this trial. NOMBASA admits that she paid money that potentially incriminates her. She is therefore testifying under Section 204 and may qualify for indemnity if the court ultimately finds that she answered the relevant questions frankly and honestly. The defense theory is that she is helping the state to implicate their client, Mapisa-Nqakula, potentially to avoid her own prosecution. But there is another layer. NOMBASA previously had her own criminal prosecution in Pretoria Specialized Commercial Courts. The Dekwa Military Police, case number 0711 of 2017, that matter has been removed from the roll following a successful 342A application. Her lawyers subsequently approached the NPA in April 2023 to report the alleged corruption involving Mapisa-Nqakula. The defense question is, did NOMBASA become a state witness because she wanted favorable treatment in her own criminal matter? The state answer is her lawyers approached the NPA voluntarily, and the state denies that her statement was coerced. What does NOMBASA have to prove? Her evidence gives the state the alleged inside story, but her word alone is not the end of the case. The prosecution needs to support her with the WhatsApp messages, dates and meetings, cash and financial records, third-party witnesses, renovation payments, and that leaves the central question: can the state collaborate NOMBASA, or is NOMBASA actually the case? See you on the next one.